Constitutional Court began hearing two challenges to the Electoral Amendment Act today. Now, at the heart of the challenges, it's whether the Act is unfair to independent candidates who are going to be allowed to stand for the first time in next elections. And this, of course, is urgent because it could change the way those polls are held next year. Two applications being heard together, one from the Independent Candidates Association of SA and one from the One SA movement. The Constitutional Court is concerned already, though, of potentially infringing on the separation of powers between Parliament and the judiciary. And our reporter, Heidi Giokos, was in court today and she joins us now. Hello, Heidi. A very complicated case, but I think essentially we just need to understand what exactly do these applicants want, because let's not forget that in 2020 this issue was before the Constitutional Court challenging the original Electoral Act. Because of that finding that it was unfair to independents, we now have the Electoral Amendment Act, but these parties are saying it's still not right.
Yes.
What are they concerned about?
Exactly. So it's all a numbers game at this particular point. So it's got to do with independent candidates being able to contest in next year's national elections. But the issue here is it's got to do with the threshold. So there's basically two issues here. You have a situation where independent candidates need to get about 15,000 signatures before they are able to contest in next year's elections. So independent candidates are saying it's very easy to get more than 15,000 votes, but it's very difficult to get signatures, because that means they will actively have to go into the area wherever they are from and get these signatures, which are public. They're not private. For example, when you vote, it's a secret. Nobody really knows who you're voting for. So that's number one. They want that threshold to be dropped to about 1,000 signatures. It's a lot easier for you to get about 1,000 signatures. I mean, I certainly don't know 15,000 people. So independent candidates are arguing that they themselves are probably going to struggle to get those signatures. The second thing is they want to change how many seats are available for independent candidates in the National Assembly. Currently it's 200 to 50. They want to change to 350 to 50. They are arguing that it is not fair. They are not playing on the same playing field as political parties, and they should be treated as the same. And just because they are independent candidates and not contesting as political parties, they should not be given they should not be treated unfairly, and they find this to be unconstitutional and unfair. And this is why they want the Constitutional Court to address those particular two matters. As much as they welcome the fact that they can now contest the national elections, they're not happy with the threshold and the fact that they don't have as many seats as they want in National Assembly.
All right, so am I right that the reason we've got 400 seats in the National Assembly, it's divided in half, 200 are for the individual votes that any candidate can get, but the other 200 are based on proportional representation, which is what the party gets, a proportion of the vote, which wouldn't include the independent. So that's at the heart of the issue. Who did we hear from today? One SA?
Yes, let's listen to what One SA had to say, because they, of course, were also arguing in court today, but they had a press briefing before the matter was heard in the Constitutional Court, speaking about why they find this Amendment Act unconstitutional, and they would like for this to be changed very urgently because elections are next year. Let's listen in.
Here because there's a number of constitutional issues which are represented by a number of different organizations. One South Africa is focusing on two elements, one being the signature requirement, which, as Michael has explained, imposes a significant barrier of entry to participate, which is obviously a violation of rights such as equality, but also the political rights of independent candidates to participate. And then the second one deals with vacancies, but actually it comes down to the fact that this new electoral system literally throws votes away, and not just two, not just three, but you can anticipate that hundreds of thousands, even millions, depending on the popularity of a specific independent candidate, will essentially count for nothing. It will be thrown away, discarded, and that is a serious injustice. There's people who literally died for everyone to have an equal vote, but also for that vote to count equally in the composition of Parliament. And so we can't actually accept any political system that says that your vote, because it's towards an independent, counts less. So that's actually the essence of the constitutional argument when it comes to vacancies and the sort of technicalities around that specific issue.
All right, so that's those are the applicants essentially. The state, we're going to hear from what they said in court, but the Home Affairs Minister himself was actually there, really frustrated, wasn't he?
Yes, certainly, Sally. He was in court today and he literally stayed right up to the end. I'm not sure if he's going to be there tomorrow because we do know it continues tomorrow for arguments and closing arguments. But the Minister has been very vocal because essentially it's up to the Department of Home Affairs to push forward this Amendment Act. It's up to his department and he is the Minister. There's been much criticism, of course, from independent candidates and other organisations saying that the Amendment Act at the moment favours political parties, and basically indicating that the Minister is favouring the ruling party, which is the ANC, and not allowing for independent candidates to participate as equally as political parties would. The Minister is saying that Parliament, essentially National Assembly, did what they were supposed to do. They acted as quickly as they could, despite the fact that they did ask for an extension, and it was literally till the very last minute that the President signed off on that Electoral Amendment Act. The Minister also saying that he doesn't understand how, if you can participate and contest as an independent candidate, why there needs to be specific rules for an independent candidate where it should just be as is. As political parties contest, so should independent candidates. This is also what their legal team has indicated, that you're going to have a situation where if the threshold is changed in terms of the seating composition, there's going to be an issue possibly where there are more candidates compared to seats. So this is also what the Minister is arguing, to say, what if you have a situation where there are a number of candidates but then there aren't enough seats in Parliament? What happens in that situation? Okay. Which it's a real numbers game, Sally. I mean, everybody, I mean, you even heard in the Constitutional Court where the justices were saying, you know, how do we actually calculate this? What is the right calculation for an independent candidate versus a political party? So everybody was sitting there with their calculators trying to figure out how this works. But let's listen to what the legal team for the Department of Home Affairs had to say.
The ICA does not object to three things. First, it doesn't object to the principle of there being two seats, regional and compensatory. Second, it doesn't object to the principle that independents can only compete for regional seats, whereas political parties can compete for both. I mean, when I say it doesn't object, it's very unhappy, but it doesn't suggest that there is anything unconstitutional about that. And thirdly, the ICA does not object to the fact that there are two ballots used and that both ballots count towards the second set of seats, which is what produces the unequal vote, if I can use it in inverted commas, or the unequal quota. So none of that is objected to. The only debate between the parties, and our learned friend Mr. Madonsela said so, he said the only debate between the parties is, did Parliament act unconstitutionally by reserving only 200 seats for which independents could contest? I thought he was suggesting it had to be all 400, but in answer to the question from the Chief Justice, it is clear. He says Parliament was constitutionally obliged to set aside 350, not 200. And that is the only debate between the parties. Did Parliament act unconstitutionally by adopting a ratio of 200 to 200 as opposed to adopting a ratio of 350 to 50? That is the only debate between the parties. Now, one would have thought on the face of it that that is preeminently a matter for Parliament. We're not talking about Parliament reserving 5 seats or 2 seats or something nonsensical. We're talking about 200 seats, half of the seats.
Yeah, it's an interesting one, Heidi, and of course it continues tomorrow, and you can see where the state is going. They're saying this is the ambit of Parliament, it's not the ambit of the Constitutional Court, and already today Constitutional Court judges saying we're not sure if we should be looking into it, because one of the suggestions I think was we can easily, the Court could put in an amendment into this new Amendment Act. So it's going to be very interesting to see what happens tomorrow. Thank you for summarising a case that complicated but important to know about because it could impact next year's elections quite significantly. Heidi Giokos, thank you so much. Do stay